have 1 minute after the hour, so I'm going to go ahead and start so we can get through our prepared deck and then leave it open for questions. If you have any questions for our panelists or myself, please put them in the chat function. I'd like to get to them as soon as you have the question so we can get some engagement going. Today's formal title is a mouthful. It is Increased Legal and Compliance Expectations Under the Proposed PCAOB Audit Standards Amendment, semicolon, what compliance and risk professionals need to know now. And that's the part we're really going to focus on. What do you need to know now? So let me get that slide deck up for us. Okay. First, our panelists, as I said, I'm Tom Fox. I'm the compliance evangelist. Lynda, you want to introduce yourself to our audience today?
Sure. I'm the designated forensic accountant on the panel. I'm an active forensic accounting practitioner, but I also direct the forensic accounting curriculum at the University of Massachusetts Amherst. In a previous life, I was a Big Four partner in the forensics practice, and I worked with a team that helped support our audit teams with high-risk audits and with situations where non-compliance was an issue.
And Vince Walden.
Thanks, Tom. Hi, everybody. Vince Walden. I'm CEO of konaAI. We are a compliance and transaction monitoring, continuous controls monitoring software platform. We work with compliance professionals as well as internal auditors to bring kind of data-driven compliance platforms to their organizations, either via the cloud or in their environment. My passion is around data analytics and how we're building out the best library of risk indicators and tests that we possibly can using AI, machine learning, as well as just the forensic expertise. Prior to that, I was a partner at a Big Four as well. Lynda and I actually worked together for a while at our the same firm. And I do a lot of work with the ACFE, the Association of Certified Fraud Examiners. If you're a CFE, you've probably seen my magazine. I've been writing for Fraud Magazine as a columnist for the past 4.5 years now. It's one of my passions and on this technology topic. So we're really excited. Tom, thank you again for kind of hosting this. konaAI is sponsoring it, but you're going to lead us through this conversation. This is something that I think has not been talked about enough in the compliance communities that we really want to bring to light. So thanks for having us.
So what we're going to talk about today is the NOCLAR initiative by the PCAOB, AS 2505, the current state of the proposed amendment, increased external auditor expectations for compliance, how to prepare for and in line with other guidance. So is there anything out there you can look towards to help you prepare, the pros and cons of the proposed amendment, and hopefully some closing thoughts really with our audience as well. So Lynda, I'm going to ask you to maybe start off with what's the issue that not only are we here to talk about today, but with this proposed amendment?
Well, I talked to a group of fraud professionals, and I mentioned the NOCLAR proposal, and the first thing I got was glazed eyes. So let me table set a minute. We're talking about a rule that the PCAOB is putting forward, and it's a rule about how an audit should be executed. Now, the PCAOB, the Public Company Accounting Oversight Board, focuses on public companies. So this is for issuers, registrants, and not necessarily for private companies. And the rule is really focused on what the auditor's responsibilities are. Now, the new rule replaces an old rule that's practically an antique. It's AS 2405, and it uses the title Illegal Acts by Clients. The first thing that the NOCLAR rule does is it changes the vocabulary. So instead of talking about illegal acts, we're talking about NOCLAR, non-compliance with laws and regulations. So that's the first thing we're going to need to do, is to teach an entire universe of professionals what NOCLAR stands for. Now, the rule has been controversial. 2 of the board members voted against it one of them saying it was a breathtaking expansion of the role of auditors. And let's just compare and contrast a bit. The old rule acknowledged that there were some limitations to what auditors could do. And it made a distinction between those laws and regulations that had a direct impact on the financial statements and other things that might be indirect, like environmental laws or employment-related laws or other things. Now, the PCAOB chair said the old rule could be interpreted that auditors had limited responsibilities for certain indirect laws and regulations that had an indirect effect on the financial statements. The new rule is much more expansive. It focuses on any law and regulation that could have a material effect on the financial statement. So it does away with its direct and indirect and opens the scope of what the auditor might focus on. So it asks the auditor to identify risks across the regulatory spectrum. So it might be things that auditors haven't really focused as much on before, like government contracting compliance or FCPA compliance, or we think about Wells Fargo or Volkswagen related compliance liabilities. And it imposes some new obligations for communication and for testing. So what this all means will depend on what is issued in the final rule.
And Lynda, if I could comment too, is that the audience here, again, PCAOB was, is meant for the audit community.
Mm-hmm.
The folks, and again, the audience here are typically legal compliance, maybe even some internal audit professionals, and they're like, well, why does PCAOB even matter to me? That's the external auditors stuff. Well, what's interesting is just as you as compliance professionals, you're thinking about DOJ, compliance with their evaluation of a corporate compliance program. If you're internal audit, you think about COSO and SOX compliance and internal controls framework and environment. Well, I'm not going to say sadly, but guess what? There's going to be a new party, a new set of suits coming knocking on your door called the external auditor, which you might have had a couple conversations in passing about the effectiveness of your program. But now your external auditor, I think, is going to be asking a lot, should this pass, the compliance professional's role and inclusion in the audit, talking to the external auditors is going to be a lot more substantive under this new ruling. And so part of the message that we wanted to get out, especially too, was, hey guys, get ready. In fact, this could happen in 2025, where you're going to be having a lot more conversations with your outside auditor if your company is an SEC registrant. And that was one of the key takeaways. I mean, it could be profound. It's just still yet to see, right, Lynda? But odds are this is looking like it'll pass, which we'll get to in a little while.
Well, an old friend used to joke that management asserts, meaning management manages the business, management does the work, and the auditors test and opine. So if the auditor is supposed to test and opine on things that include a broader set of laws and regulations, they're going to be leaning on the work that you're doing as compliance professionals. They're going to be looking to what management in the organization has done to map their laws and regulations, to understand their risks, to respond to their risks. And in fact, they'll be audited like other parts of the financial reporting supply chain.
Sounds lovely.
Yeah, I've never met anybody who says, I really, really want to be audited this week. On the other hand, Tom, maybe this is a great time for you to jump in. The compliance community has largely been supportive of this rule, and I think sees some validation in the idea that compliance with laws and regulations and the work that they're doing inside the organizations, deserves A, respect, B, resources, and C, to be an important seat at the table. So what's your perspective?
I absolutely agree with those. And I would add a couple of reasons why I think the compliance community has largely supported this. One is the compliance community is very collaborative. We're collaborative across verticals. We're collaborative within industries. We collaborate literally all the time. You can always pick up the phone and call another compliance officer and say, hey, you ever face this situation? Now, no one's going to give away trade secret information, but there are no trade secrets in compliance. There's about 8 components to every compliance program, whether you formulate it as the hallmarks of an effective compliance program, the OECD, whether it's anti-corruption, whether it's anti-money laundering. So a lot of collaboration. So we are used to collaborating. And I think there's a large part of our community that views this as another step of collaboration, number one. Number two, I advocate that compliance is a business process. Mm-hmm. And as a business process, you always want to put a second set of eyes on whatever you're doing. Mm-hmm. So this brings a second set of eyes. Now, you've suggested, Lynda, that the second set of eyes may come with some pain or at least some work for compliance. But I think most compliance professionals welcome a second set of eyes, one for validation, but for improvement and continuous improvement. Number three, the last point you raised, which is I think it adds to the prestige and importance of compliance, because now compliance can go to management and say, we either have to get this ready for an external audit, or if there's an external audit that shows something, material weakness or other, we have to fix this if we're a U.S. public company. And if not, we may get a little letter from the SEC or even the Department of Justice. So I think really for those 3 reasons, compliance largely supports this. But Lynda, I wanted to ask a question, and if it's too early to ask it, meaning you were going to answer something along these lines throughout the presentation, in bullets 1 and 2, you have the phrase, or there is the phrase, material. There in bullet 1, material effect, bullet 2, material misstatement. And the question I want to pose is, at least in anti-corruption compliance under the Foreign Corrupt Practices Act, internal controls and accounting controls, there is no materiality standard. And so does that present a potential disconnect from what external audit would look at, or is the bullets as they've been laid out here completely consistent with what an external auditor would do, whether they were looking at IT, HR, or compliance?
Well, I think I'm going to tease out 2 different ideas. One is whether the size of the transaction needs to be material to be a violation of law versus the impact of a violation of law or a potential violation. So auditors are really looking at a lens of the entire financial statements, which isn't just the numbers, it's also the disclosures. Mm-hmm. And asking, is that all fair? Is it all, when taken as a whole? So the materiality standard is really, for this, is focused on the financial statements, meaning you might say, for example, this is just an emissions regulation, the fines are very small. But if the issue is significant, as it was in Volkswagen, and will result in a material penalty or a material risk to the company, it may require disclosure, even if the ultimate amount cannot be quantified. So I think they're both using the words materiality, but in slightly different contexts. I think, though, you tease out a really interesting question, which is the implementation of this is going to be really tough in some respects, because you might have, as we know with FCPA, very small transactions that create big liabilities. You might have situations where the compliance question is fine and difficult. And so assessing the materiality of regulatory non-compliance has always been a toughie. Yeah. But it's even more tough when you're as early as possible in the identification stage. So if you identify something that's a potential regulatory problem, maybe it is or isn't. The regulator doesn't really know about it. We're not sure what their posture would be. We're not sure what the fines and penalties would be. There's a lot of not sure in some of our hypotheticals in the very early stages. And I think there's some tensions on disclosure of really early stage issues. So, we find something, we feel a little hinky about it, we're still trying to figure it out. The quarterly filing is here. What should we do? Those questions have always been there. So this is not a unique problem. Auditors have been dealing with this for a long time, but we'll be doing it now as a profession with a broader range of regulatory, a broader horizon, and potentially, depending on who you talk to, a greater expectation of detail in the work of the auditor, which will translate into questions of compliance officers and, looking to audit clients, companies, to have their compliance house in order and ready to be audit tested.
All right. Let's move to the current state of things. And Vince, you want to sort of walk us through how we got to where we are in August 2024?
Yeah, and in fact, one of the questions that came in, I just will answer it live, is that if this gets passed this year, will it become effective in 2025's audit period? And again, we're not the PCAOB; it's up to them and the SEC, I would imagine. But what I'm hearing, I'm talking to some of my friends in the Big Four, and what I'm hearing is that it's generally, and again, by no means am I speaking on behalf of them, but the general thought is that yes, it would be involved but this could be applicable for 2025. So again, no one knows for sure, but if this passes, what I've been hearing from my friends at the Big Four, and I encourage you to ask them, is that this would be effective in 2025's audit year or whatever the fiscal year of your company is that includes 2025. So it's coming. As a little bit of history, it was originally, remember, it was proposed last year. And Tom, it's funny, when I first brought this to your attention, you're like, Vince, I already wrote about this back in last year. And no one really made a big deal out of it. No one thought, and again, I'm just generalizing, compliance community said, oh, that's audit, that doesn't apply to me. Well, guess what? It's going to apply to us, compliance professionals. The initial comment period closed back in August of 2023. And I don't think there was too many questions. And Lynda, like you said, there was too much controversy among auditors of like, what do you mean? I don't want to be practicing law. I'm not in a position to determine whether we've broken the law or not. I'm not a lawyer. And so they reopened the comment period in February of this year. But now that comment period is closed. They had a roundtable in March 6th, which Lynda, I think we'll talk about in a little bit. You read some of the comments, and it was just hundreds of pages of comments. But comments periods are now closed. It's done. And I don't think they're going to open it back up. I mean, who knows? Maybe. But it's under review by the PCAOB. And so this is coming. And like I said, what I hear is that the general expectation, it will pass in some form. But this is going to likely pass. It could happen tomorrow. It could happen in December. No one knows for sure. But this very well will be coming.
All right, we're going to have significant increased auditor expectations. Lynda, could you walk us through some of the sort of your initial thoughts on what those might be? And Vince, then ask you to chime in as well.
Well, I'll say first, the standard asks the auditor to identify the risks that might have a material effect on the financial statements. So that can include asserted claims and known issues, or maybe to think about regulatory risk earlier in the risk cycle. So I think what that risk assessment is always the starting point. some of the commenters said, I'm going to need to know all of the laws and regulations everywhere in the world. And even the lawyers laughed.
Come on. Yeah.
But the questions, I think, are really, I think it calls for the company first to have a great deal of rigor around risk assessment for its own sake, and for the auditors to begin to start with that. Then I think the other thing is to look at whether or not those risks are adequately mitigated with respect to the financial statements, which means testing, audit testing. So it doesn't mean they'll be testing for every law and regulation, but if something's material or could have a material effect, you may see a more expansive view about that. Vince, some of the thoughts you might have had.
Yeah, and when I think about the DOJ's components of an effective compliance program, it was, one of their 3 principles was, does your program work in practice? Which was one of those 3, does your program actually work? And that the whole theme of that guidance was show me. And that was before an audience of DOJ. It's almost the same as if you were going to be in an external auditor. Now, fortunately, you're paying the external auditor. You're not under duress of a DOJ investigation in that context. But I'm thinking the questions will be similar. Show me, don't just show me policies and procedures. Show me how, in effect, it's actually working. And that's where, again, as a data analytics professional and someone who's passionate about building data-driven compliance programs, that's why I took note of this, of like, oh, wow, now the external auditor is going to want to see audit evidence of continuous controls monitoring around certain risks. They're going to want to see your risk assessment, a data-driven risk assessment for how you've taken into effect the applicable laws that could be impactful to your organization, and you've thought about that in your risk assessment. And when your test of transactions, and here are evidence of, here's where we looked at data, we found issues, we remediated them, here's our process to give the auditor some level of assurance or comfort that you have controls in place, that you were looking and not asleep at the wheel per se. Those are all important. And so, some of these themes, from a risk assessment, the mapping of laws will be important. But if you're looking for, as you think about 2025, and again, I'm not saying it will pass or it wouldn't be effective, but generally it's the comment period's over. This thing's probably something's going to happen soon, or maybe not, given the election in the United States, who knows? But if this does pass, you're going to want to have compliance professionals are going to want to have a conversation with their external auditor on what's your interpretation of these expectations. You'll need to have that conversation up front and get ready, because they're going to want to see data. They're going to want to see audit evidence.
Mm-hmm.
And that's, I think, one of the messages that at least I wanted to get across to this community.
Two things that are sort of nitty gritty that might make a difference in terms of auditor expectations is understanding the audit calendar. So what are they doing at the quarters? What are they doing at the year end? What do they need you to do as a compliance professional? And because auditors are calendar focused, we've got to get our work done at a particular time. And the second thing is documentation. So many companies are rigorous with respect to their documentation. Auditors' view is if it isn't documented, it didn't happen.
Right.
And that's because that's the standard that we're held to, and we're to look at the evidence. So to the extent that you might not have been as calendar driven or as well documented, now's the time to up your game.
That's a great point. Calendar driven. And remember, going back just a little bit, remember how this all works with the PCAOB. PCAOB is the auditor of auditors. So if you think about it, and again, like you said, if it's not written down, it's not evidence. The worst thing, and again, having been, and Lynda, you too, having been a former partner Fortunately, I wasn't an audit partner at the Big Four, but the worst career thing that could happen to an audit partner is to get a negative review or a negative report card from the PCAOB on a missed or bad audit. So this is like non-negotiable for the auditor, because that's a very career limiting move for that auditor. And because the PCAOB then reports on the Big Four and the other audit, all big firms that are publicly, that are auditing publicly traded companies. If you get a bad audit report, that's a ding that's publicized. And they, and so that the point being, it's very important that that auditor does a thorough job. There is no, well, we'll get it next year, or, I would hate to have it not sign off on an audit or have that be a qualified opinion because of it. So this could be taken seriously. And again, the scope is still yet to be determined. Tom, what are your thoughts? What some of the clouds would you offer up in this?
I want to pose a question to you guys,
Okay.
and it's around the expectation of detailed review of compliance and investigations programs. And I want to even dive a little bit deeper into investigation programs. So let me set the stage. Last week, the Department of Justice announced a new whistleblower incentive program.
Yeah.
Under that program, if a whistleblower comes to the Department of Justice, but a company within 120 days of that investigates and then self-discloses to the Department of Justice whatever the issue the whistleblower brought was, the company is still eligible for a full declination if they meet the other criteria of extensive remediation, extensive cooperation, and profit disgorgement. So that's a change. And many in the compliance community feel that's put more pressure on investigative programs, both actually your speak up culture and your investigative program. Is that the kind of thing that an external auditor would expect a company to have picked up on and at least considered for their compliance program? Or because of the number of steps I had to take, is that really too speculative?
Wow. Lynda, what do you want to?
Well,
I have a thought, but go ahead.
Yeah, it's long been a requirement or a part of many audits that the auditor will look through the log of whistleblower hotline calls, may probe the response to specific events. Sometimes people blow the whistle directly to the auditor, so we often are receivers of whistleblower things. And we're also looking oftentimes to regulator inquiries. So if there's something the regulator is asking for, it's not at all unusual for us to follow up. It's unclear to me whether the 120-day window to get the self-disclosure credit will affect this auditor requirement. But I think it does increase the sense that compliance is on a calendar and maybe on a stopwatch too, because response times are going to be very important. And the idea that you can sit on a potential non-compliance issue for a long time is long over, if it ever was, because of the DOJ's program, but also because if your auditor is involved, they probably will need to know how you're going to call the ball with respect to that issue. And if you cannot demonstrate that the issue is clearly inconsequential, they may ask for more evidence before they'll sign off. So, as having worked as an investigator, time was always a huge issue. As an auditor, time is always an issue, and if compliance officers aren't already feeling that hot breath on their neck, they will now.
All right. Now let's turn to, we've raised several of the questions, issues, and perhaps even problems. Now let's turn to some of the potential solutions you guys see. So what can the compliance and risk profession do to prepare should this pass? And I'm just going to say when it passes. Vince, you want to start off with some of your initial thoughts?
So this caught my attention in my column for this month when I was writing, raising the attention for certified fraud examiners, and I said, hey, look, CFEs, get ready, because many CFEs are in the compliance and profession. Many are part of the internal audit or compliance teams or internal investigations teams, and so this was one of my themes. But first and foremost, I would say take a look at the NOCLAR. Just Google AS or PCAOB AS 2405 NOCLAR, and you'll get the documents, and you'll get but be familiar with those three themes that Lynda said. Have a discussion. I mean, the first and foremost thing, have a discussion with your compliance team, and especially your external auditors, and maybe even bring it up in your board discussions. Well, especially you'll have to bring it up if it passes. But this could come, and I think it's more probable than, I'm going to use an audit term, more probable than not that it will pass. Do you agree with that?
That's actually part of the controversy.
More like, yeah. Who knows? We can define what that means. So, but that's, talk to your team and your auditors about this and what would they expect for your organization and your company risks, and then update your risk assessment process. I think, you need to include non-compliance with laws and regulations. As compliance professionals, what risks your company has, especially from a legal perspective and regulatory perspective. Make sure they're mapped to what controls you have in place. Because remember, an auditor thinks controls. Here's a risk, what controls you have in place? And another risk, what controls? Oh, you don't have a control in place for that? That's a finding. And so they're very objective that way. And I also think one of the misconceptions in compliance is that we're done after our third-party due diligence. And this is something that I get on my soapbox on a lot, is that when you think about non-compliance with laws and regulations and bribery, corruption, sanctions, trade compliance, etc., when does the fraud happen? The fraud does not happen during the due diligence. Yet most compliance professionals spend millions of dollars or huge amounts of time and resources doing the due diligence of the third party. Now, that's important. You can't get rid of it, but that's not it. Where does the fraud happen? The fraud happens when you actually do business with the third party, and that's what the auditor is going to want to look at. Because when you're actually sending money or receiving money, invoicing or paying invoices, recognizing revenue, etc., when you're doing business, that's, and I'm going to use the DOJ's term, that's the lifespan of the relationship when you're actually doing business. So don't just think that a due diligence program to vet the third party is enough. Odds are it's probably not, especially if you're an SEC registered company. And then, I would also say, and again, from an analytics perspective, because again, this is the auditor and you show me the evidence. And if you're not doing any type of anti-fraud or anti-corruption or ESG type of metrics, why not? You better be able to justify why you're not doing that. And I can tell you, we don't have budget is not a sufficient answer to the auditor nor to a DOJ regulator. And that's why, I put in this point, it's not just the PCAOB. I mean, this is just good practice from the DOJ, the Serious Fraud Office, to even in the internal audit community, COSO and internal controls. So pick your regulator. So that's kind of my theme. Lynda, what's your thoughts in terms of being able to prepare?
Well, I think, again, coming back to, the management and leaders of the company, prepare the financial statements and run the business. And if you don't have a strong compliance program that's mapped to your NOCLAR risks, then the auditor is not going to just, sit down and say, I can't audit. They're going to do more work. They're going to, in auditor world, they're going to vary the nature, timing, and extent of their procedures, meaning they're going to audit more to fill your gap. So where do I see this? I see it's an opportunity. If you have a very strong compliance program with good documentation and you've got robust stuff, I would be trumpeting that, and I would be talking about how other companies are going through heck, and you are, able to work closely with your auditors to keep the audit effort manageable and sane and responsive to what the company is doing. I think where it's going to be a heavy lift for everybody is when there's gaps, and the gaps are significant. So if you, if you do have gaps, I think you can say, pay me or pay your auditors, because it's a call for strengthening the process. I think the PCAOB's overall goal is a terrific one, and that is to make sure that investors have good information, and that companies while I think they're hopeful for some deterrent effect, their main issue is get it right and tell investors the whole truth. How we get there, I think management, the compliance people on this webinar, are the first line of defense. And so I see it as a great opportunity.
Yeah.
Vince, we've had a question come in that would seem to be right up your alley, and let me just read it. Continuous monitoring of fraud and compliance is required. Does no CLAR rule mandate this monitoring with data analytics?
No, in my review, it does not specifically mandate the use of any type of prescribe any type of data analytics. But it doesn't say you must do these tests of transactions or you must do these. It's so it doesn't mandate per se. But if you think about how an auditor thinks, or any reasonable person who is going to review the processes and controls, they're going to want to see data, and having your risks mapped to the relative or respective laws, and then saying here are the controls in place and here's the data showing how we monitor is, yes, you use data analytics, but it's really process. You need to show that process. One of the things that I put on this slide here, if you think about your risks within an organization, and again, put cyber aside and state-owned actors aside because that's the cyber world, but there are only 3 entities that you need to think about that can rip you off or that could commit a non-compliance with laws and regulations. There are vendors, customers, and included in customers would be distributors, wholesalers, etc., people you sell to, and employees. Those are the 3 entities. And those types of risk areas where you need to monitor, I gave some examples, vendors, conflicts of interest, bribes and corruption and kickbacks, FCPA, transaction anomalies, segregation of duties. These are the types of things that accountants look at, but more and more now compliance professionals also look at, because this is where you'd want to set up your continuous controls monitoring to demonstrate that you do have an effective data-driven compliance program. So that's where, again, analytics is not mandated because every company is different and they can't prescribe it. It wouldn't make sense to prescribe a specific analytic that must be done, but that's part of your risk assessment.
All right. Some of the best guidance. I'm going to maybe step in here and at least start with the evaluation of corporate compliance programs. That's the 2023 version, because this is presented by the DOJ to the compliance community. It's a series of issues and, more importantly, questions the DOJ would ask you if you find yourself under an FCPA or other compliance-related investigation. But it goes through the hallmarks of an effective compliance program with a little bit different focus, and it really is looking towards, is your program effective? Is it well designed? And is it well designed? Is it effective? And are you testing it? So for me, the ECCP, as we call it, is one of the key documents that a compliance professional can use. But May 2023 COSO ACFE Fraud Risk Management Guide is equally popular and perhaps more importantly, equally important. So Vince or Lynda, you want to maybe tell a little bit about what this document is and how it can be used?
Sure. The Fraud Risk Management Guide is issued by COSO with ACFE. But as you know, COSO has a broad range of sponsoring organizations. So it's probably the single widest sponsorship in terms of industry organizations. And it like the ECCP, it talks about the elements of a successful fraud risk management program. And while it integrates with the ECCP and some of the earlier guidance from the DOJ, it provides, I think, a really good structure for approaching these kind of risks. The other thing that I love about it is, it focuses on fraud, which is one part of NOCLAR. So, it's a great Venn diagram of guidance with ECCP and the Fraud Risk Management Guide.
Yeah, and I would add
lots of overlap.
Yeah, and adding to that, I would say, if I was a compliance professional and I had to sit down and convince my external auditor that my program was sufficient, I would pull these two documents out and say, look, this is how we map to the DOJ evaluation of corporate compliance programs. And again, that's the attorney speak, because that was written by attorneys for attorneys. Interestingly, the COSO Fraud Risk Management Guide was written by accountants and anti-fraud professionals for accountants. And who's your audience? The external auditor? That's an accountant. That's accountant speak. COSO's is accountant speak. But you want to show that they're both there. Legal, NOCLAR is a legal concept. COSO is an accounting concept. Demonstrate that you align to both, and you'll give your external auditor some good comfort. And the great news is, and Lynn and I can say this because we both co-authored this document, this Fraud Risk Management Guide. The great news is both almost say this, well, actually, both say the same thing from a thematic perspective. They all say, do a risk assessment, have a control environment in place, have continuous monitoring, do your risk assessment, so I think you'll find there's a lot of parallels between these two documents. You don't need to create a new thing. Both say the same thing. So if you're complying with ECCP, you can probably pass the fraud risk management test. So use that to your advantage. These are two guides that will help satisfy your external auditor.
So yeah, COSO's known for its risk frameworks. So it's definitely accounting speak. And I also want to just do a shameless plug for David Cotton and Sandra Jonigan, the principal authors, and the other members of the task force that worked on it.
Yeah, no doubt.
Vince, you in an earlier slide talked about the life cycle of third-party risk management, and I think you hit it spot on the head when you said that your work starts when the contract's signed, because that's where the rubber meets the road, which is the management of the ongoing relationship. Can you talk a little bit about the expectation of compliance monitoring after the contract signed, and perhaps more importantly, how can a company meet this requirement? Or, as I have said many times, it's really when the rubber meets the road of managing your third party.
Yeah. And these three questions that we put up here, remember, this is the DOJ asking you these questions. So I've switched gears from PCAOB back over to DOJ for a minute, but for this audience, you get this, and you've all read this. And that point of throughout the lifespan of the relationship, or primarily during the onboarding, question. So you can bet your auditor is going to ask that same question. And do compliance and control personnel, do you have sufficient or direct access? I've had conversations, with compliance officers saying, hey, worried about commissions or payments to third party, to their distributors or what have you, in let's just say in Nigeria or in West Africa or something, and they go, oh my God, I can't get access. That data doesn't exist. I can't get access to that data. There's no way. Of course you can, because it's tied to your financial statements somewhere. Otherwise, the audit wouldn't pass. That data does exist. You're going to have these types of conversations. I think these are very fair auditor questions that will be asked of you. Do you have access to relevant data sources? And what impediments exist that might limit access? Oh, IT won't, what I hear a lot, IT won't cooperate with us. They're too busy. That doesn't, you can't ignore that. And that's not a good answer. And so, keep what the DOJ is going to ask is very similar to what I think an auditor might ask. That's why we wanted to kind of get this as just the thought. If you can pass this litmus test, you're in good shape, I think, with an auditor.
I really like this slide, Vince, because in the compliance community, we don't see it enough. We see it perhaps if someone reads the ACFE report to the nations. But the first time I saw this slide, it really helped open my eyes as to where bribery fits in to both fraud and corruption. So could you maybe take us through the fraud risk area to consider really by focusing on the fraud tree?
Yeah, I love giving this story and analogy, and I think the audience, you'll love this and appreciate it too. If you ask an external auditor, what is fraud? They're going to say, oh, it's revenue recognition, it's financial statement fraud, it's cooking the books. If you ask a legal person, what is fraud? And again, of course, I'm generalizing here, but there is inherent bias in our educations and backgrounds. If you ask a lawyer, what's the definition of fraud? They're going to say, oh, it's bribes and kickbacks, it's illegal gratuities, it's economic extortion, it's sanctions and trade compliance, it's et cetera, in the white collar crime. That's under corruption. If you ask an internal auditor or a finance professional, what's the definition of fraud? It's cash larceny, it's payroll fraud, it's disbursements, it's T&E fraud, it's theft of assets, inventory, etc. Now, not included here is if you ask a cyber person, an IT security person, what's fraud? They're going to say ransomware, Trojan horses, viruses, bugs, etc., spyware. And we're all right? But the fraud tree brings it together. It's all fraud. But what's important is that you don't let your educational bias close your eyes to all the different types. What I think the PCAOB is doing is PCAOB was strictly in the green primarily up until now for the most part, and a little bit of the dark blue, the asset misappropriation, financial statement fraud. But what they're doing is they look at fraud holistically, and there's FCPA, there's sanctions and trade compliance, there's human rights, there's ESG reporting, all these legal concepts that need to be under this definition. One of the things that I did, I included a screenshot of my software, but look at all the tests that can be run. And again, this is just for vendors. 97 tests around payments and 84 around purchase orders and 85 around invoices. There are so many tests of transactions that can easily be run by pouring your data through to give you insight and transparency into the business operations without having to spend huge amounts of money or huge amounts of people to review. It's not an email review. But being able to demonstrate that we look at 100% of our data, we run it through some transaction testings, and we look at just the top 10 results. Or, we take 200,000 payments and we risk score them from 1 to 200,000, and we look at the top 20. That's great. But it's not as, it's now kind of attainable for companies to do this cost effectively. And I hate to say comply, but this is a defensible message. So that's my soapbox. So thank you, Tom.
Well, we were joking as we were prepping. I guess I wonder, do we need some new branches on our tree?
Mm-hmm.
Because when you think about all the different kinds of regulations that could affect the enterprise, now all of a sudden, if they could have a big effect on the enterprise, they can have a big effect on the financial statement. So, you mentioned a few of them, but I also think about industry-specific regulation, like all of the healthcare billing and healthcare service requirement legislation, government contracting, financial services. And each one of us, has an industry that we know the regulations very well. Our auditors will need to know those regulations, and so having a map of the different groups of regulations you think are important for your organization might start with this broad tree, but it might not end there.
Good point. Good point.
Okay. We've got about 10 minutes left. So why don't we maybe give some final thoughts, but really incorporate what you guys see as pros and cons. And I'll start off because I'm pretty bullish on this. I feel like this is a positive for the compliance profession. I think it will enhance the profession, but equally importantly, it will enhance corporate compliance programs. I understand there will be cost. I understand there may be, if not pain, certainly some more work. But I think compliance professionals generally will welcome that work because what they're going to get out of it is a roadmap, if needed, to remediation. And that's what you want as a compliance professional. And I know that's shorter, but I'll maybe pitch it over to you, Lynda. What do you see as some of the pros and cons?
Well, I'm an anti-fraud professional and a compliance cheerleader. So I'm really positive about clarity in the rules. And this was an antique rule that wasn't really serving us as well as it might. That said, I'll tell you that some of the commenters are concerned about the cost. Some of the commenters are concerned that the auditors might need more education or more support from specialists for areas that aren't normally part of an accounting or auditing education. And I think it'll be a bumpy year. I've said, publicly, I think at least the first year is going to be a heavy lift. But our goal is to, when I think about the auditing profession, our goal is to be able to issue opinions that help the investing public. And so I'm very supportive of the overall goal. I'm really looking for the details in the final rule because I think some of God is in the details, but sometimes the devil is too. And working those details out, I think it'll be a bumpy year.
Yeah. And I'd comment, I think, Tom, I'm gonna recite just quickly the 5 kind of observations that the Center of Audit Quality, which was kind of it's an association that just kind of it works with auditors. They issued an opinion letter to the PCAOB. This was back in August of last year. So when it first came out, this was what their concerns were. And it addressed some pros and cons, but I think it was a really good distill of the 5 issues that happened. And the first one was they said, look, this is a fundamental shift in the audit objectives. Up until now, you've been asking us to look at the financial statements. Now you're asking us to look at the laws that might impact the financial statements. That's a big shift. You're asking, it's more forensic and it's more of a compliance audit, or it trenches into a compliance audit is kind of what they said. So that was the first issue. The second one is scope. We don't know what this scope means. Again, this is the auditors. We don't know what does it really mean to include all laws and regulations. And Lynda, I liked your comment earlier where, the auditor said, well, I'm going to have to familiarize myself with every single law on the planet to see if it applies. Well, that sounds like an audit answer, but that's boiling the ocean. But that scope was a question. The third one was auditors are not lawyers. Don't ask us to be a lawyer. And we're not forensic accountants. We're not trained in forensics. We're trained as auditors. So don't ask us to be a lawyer and determine whether we've broken the law or not. That's a lawyer call, not an accountant call. So that was an issue. I think that one has been addressed in a lot of the comments. I mean, there was talk early that, gosh, you're going to need to retain outside counsel to get a clean audit opinion. That would have been a windfall for external law firms, but that's not going to happen. I think that was pretty much suppressed, but that was the original question. The fourth was, hey, wait, it's management's responsibility to determine if they're violating the law or not us. So it was the role of management versus the auditor. And again, management's responsible for that financial statements, not the auditor. We're just opining. But I think that's not ultimately going to fly because, again, the consensus is auditors need to take more of an active role in the assessment of non-compliance of laws. And then the cost. The fifth one was the cost of we don't know. And Lynda, what you said, this first year might be rough when it comes out. We don't know yet. Auditors are probably going to go back to their clients and say, look, we need to increase audit fees and do more substantive testing around non-compliance with laws and regulations. We need to schedule more time to meet with the chief compliance officer, schedule more time to meet with your head of investigations and find out what we're doing. Those things, look, they bill by the hour. And so, or they do it by fixed cost, but it's based on an hourly model. This is increased in scope, but so that's I think what the pros and cons might look at.
We are now at the end. This is information on konaAI. If you'd like to request a demo, Vince and Lynda, we've got a couple of questions, so I wanted to pose those to you as we have just a couple of 4 minutes left, in fact. So do you have any advice for companies that have a siloed approach to fraud and compliance?
Go ahead, Lynda, if you want to comment.
You know, I think you're going to need to work together. And it doesn't mean necessarily that your teams need to merge, but you'll need to be responsive in the way you explain your approach to the auditors. But I can see siloed approaches working. Whether they work most efficiently and effectively, maybe you all know as much as I do. What do you think, Vince?
Yeah, breaking down the data sets, I think, compliance professionals should probably, again, talk to internal audit, make sure you're coordinated in your approach, because the external auditor, remember, external auditors already talk to internal audit. In fact, external auditors rely on the work that internal audit does to help keep their audit fees low. And so internal auditors, when they trust that the effectiveness of the internal auditor is good, they'll accept it. I'm kind of thinking that compliance is going to be a little bit of the same. I think you should go ask your internal audit folks, compliance professionals can say, look, what's it like working with the external auditor? What do they ask of you? What do you think they're going to ask of us? So I would talk to them about it. That would be as a start, and say, what do you think about this NOCLAR? And what procedures do you perform so that we don't repeat the same procedures? Let's not do duplication of efforts. But here's what we think we need to be able to map to and demonstrate. So, I think it's just communicate within the organization and share the data. Oftentimes, internal audit has great data that compliance professionals can leverage.
Okay, guys, we're nearly at the top of the hour. We haven't announced, but I will say that we will be following up with a copy of the slide deck. And at some point, we'll have the recording available for those who may want to listen to it. I'm certainly going to take the advantage of posting it on my site, the Compliance Podcast Network as well. This has been a great webinar. I hope our listeners will think about this NOCLAR rule and reach out to both Vince and Lynda with any questions you may have. Of course, their contact information is on the slide deck. I know they'd be happy to help out. So we are at 59 minutes after the hour, guys. I think it's probably a good time for us to conclude this webinar. Thank you so much, Vince. Thank you for konaAI for sponsoring this. Lynda, thank you so much for bringing your expertise as well. And I hope we can do this again when the rule gets passed.
Yeah.
Thanks so much.
Bye, everybody. Thank you for joining.
Thanks.